This is WAEN-TV.com. Now, welcome to the Jackee Show.
Which way should I look at the camera? Which way should I look? Which way should we look so we have the best photo of the camera?
Okay, you should always be looking. That was a dry run.
No, that was live. We're on.
Oh, we are?
Yeah, talk to the camera.
Okay. Good afternoon. I'm Attorney Jacqueline Gibson in Atlanta, Georgia. Today we have a guest with us, and that is Attorney Jackie Patterson. He's a well-known criminal lawyer in the metro Atlanta area. Attorney Patterson, will you please introduce yourself?
Well, Attorney Gibson, it's such a pleasure to be here with you tonight. In fact, you've been my role model now for about 20 years.
Don't tell my
Yeah,
age.
yeah. Yes, you have, about 20 years.
Thank you.
I'm from Atlanta. After high school, I spent 3 years in the Army as a paratrooper. Got out, I joined the Atlanta Police Department. Got my undergrad and my master's while I was on the police department. Left there and went to law school, and been a lawyer now for 23 years. And my practice is criminal defense.
Attorney Patterson, you have a very interesting and colorful background. Tell us, if any, how serving as a police may have come helpful to you in your career as an attorney.
Oh, absolutely. You know, the 6 years I spent as a police officer, certainly you're making arrests, you're doing investigations, and now that I'm in criminal defense, I do a lot of my own investigations, so it really, really worked out well to have that law enforcement experience.
Your own hands experience, did it not?
Absolutely, absolutely.
So you've seen both sides of the case.
Oh, it's no question. I'm fortunate that I have the distinction as the only criminal defense attorney in Georgia that has served as a police officer, police chief, municipal court judge, state court judge, and superior court judge. Mr.
Patterson, Attorney Patterson, is there anything you haven't done in law enforcement? You haven't been a jail warden, have you?
Not at all.
You've worn many hats in your distinguished career.
Yes, 5 public offices.
That's fantastic. I know a lot. You comment on the news about different subjects of interest and criminal cases. I've often seen you a lot on the news.
Yes.
They always look for you, and I look for you. If anything going on wrong in Atlanta as it pertains to criminal, I'm waiting and saying, when is Attorney Patterson's going to show up? and eventually you do.
Thank you, thank you. I've enjoyed it. I serve as a legal analyst for WSB, Fox News, 11 Alive, CNN. I've been very, very blessed.
And you are, so to speak, a Georgia boy?
Yeah, absolutely. From Atlanta, Georgia. Absolutely.
Fantastic.
Grew up in Southwest Atlanta and went to Booker T. Washington High School.
Great. This show is to inform the public about different topics they may have an interest in. So it'll be very informational for a lot of our viewers.
Absolutely.
Could you tell us the difference between criminal law and civil law? And so many times people, they get them confused. Could you explain that to us?
Absolutely. The way it works is that anything, I try to keep it simple, anything that you can get a traffic ticket for or get arrested for, that's considered criminal defense. Everything else is civil, whether it be personal injury, family law, car accidents, all of that is civil. So always remember, the public need to remember that if you can get arrested for it or get a traffic ticket, that's criminal, and everything else is civil.
Could you divide up for us the different levels of criminal law?
Absolutely. I guess you're referring to criminal courts, different criminal courts.
What's a felony, a misdemeanor?
Absolutely, absolutely. A misdemeanor is anything that you can get 12 months or less in jail. You can never go to prison for a misdemeanor. You can only go to the county jail, and the maximum punishment is 12 months in the county jail or less, and a maximum of $1,000 fine. Anything over that is a felony. For an example, anything that you can get 1 year in prison up to life in prison, that will be a felony, such as felony would be things like drug trafficking, kidnapping, armed robbery. A misdemeanor would be things like DUI, speeding, reckless driving.
And what are some of the problems that a felony can have on one's life?
Oh, it's major. First of all, you don't even want to be convicted of a misdemeanor unless it's a traffic misdemeanor. But a felony, once you become a convicted felon, you cannot vote, you cannot carry a weapon, you can't serve public office. Your whole life is almost destroyed. Most people end up working at car washes and doing other things or having to start their own business. But once you become a convicted felon, that is a tough road to follow at that point.
It's almost like a death sentence.
Oh, absolutely. I mean, that's the last thing you ever want to be as a convicted felon.
Perhaps they have to find a job for themselves, to be self-employed.
That is correct.
Perhaps.
Absolutely. Or you have to find an employer that will trust you on their job.
Do you believe in once you've served your time, it shouldn't follow you anymore, your background?
I totally agree with that, but unfortunately the legislatures just don't seem to follow that theory. The legislatures believe that once you become a convicted felon, you're pretty much done. Now, you can always have your civil rights restored to where you can carry a gun and serve on jurors, but you're still a convicted felon, and once that's on your record, it is almost a done deal.
So that's a big burden to you. And also, having a felony on your record, sometimes some licenses that you perhaps can get, it may hinder or stop that?
Oh, absolutely. For an example, if you're a convicted felon, 99.9% of the time you cannot be an attorney. You can't be a police officer. You can't hold public office. If you're a nurse, for an example, your certification will be revoked. There are many, many disadvantages to being a convicted felon.
So if you are a lawyer having a professional license, if you get that convicted felon, what would happen to your license?
The State Bar of Georgia will automatically revoke your license and you will be disbarred. That is almost a guarantee in everyone that's been convicted of a felony who has been a lawyer.
Okay. Moving on here, could you please tell us the different classes of criminal court?
Oh, absolutely. For an example, I've served in 3 of those classes. You have municipal courts, you have state courts, and you have superior courts. Those are the 3 basic. Now, there are other ones, but those are the 3 basic. Municipal court is basically a traffic court. That's where people come to court charged with speeding, DUI, reckless driving, running a red light. That is municipal court. Then the next step will be state court. Now, state court handles all those things that municipal court handles, but they handle more things. For an example, a municipal court cannot handle a misdemeanor simple battery, but a state court can handle misdemeanor simple battery, because municipal courts and state courts are what you call courts of limited jurisdiction. So although municipal court can handle certain things, there are still certain things they cannot handle. So the next class is state court, and then you have superior courts. And superior court handles armed robbery, kidnapping, divorces, all those things that state and municipal courts cannot handle.
Very good. And when one is arrested, how does the arrest process begins, and what are the steps that a defendant goes through in the criminal justice system? Oh,
absolutely. Well, there are several ways that an individual can be arrested. First of all, you can have, for an example, let's say an armed robbery and the police catch you on the scene. Then clearly they're going to arrest you right there on the spot. So that's one way.
You sure that if they can catch you?
If they can catch you, absolutely. That's the first step. The police can make an arrest on the spot if he has probable cause to believe that a crime has been committed. And then the other way is that it's called an application for a warrant hearing. For an example, let's say you have 2 individuals who have a private contract, for an example, where one is supposed to do something with money, in a contract situation. But let's say he used that money for some other purpose other than what it was meant for. Then one party can go down to the magistrate court in whatever county that the event took place in and file for what's called an application for a warrant. In that situation, the person is not arrested until the magistrate court sends that person a notice saying that John Doe is attempting to have you arrested. Once you show up at that hearing, then after the person who potentially will be arrested give their side of what occurred, and the applicant, who's the person that's trying to have the person arrested, give their version, then the judge will make a determination whether there's probable cause to make an arrest. If the judge believes that no crime has been committed, then the judge is going to dismiss that application and the person is free to go and never arrested. If the judge believes that it is probable cause, that person will be taken into custody immediately and be booked into the county jail and have to make a bond.
Attorney Patterson, for those of us who don't know, I know as lawyers, we understand. Give me a little information about what is probable cause.
Oh, let me tell you, it goes all the way from a police officer all the way to the Supreme Court of Georgia. The standard has never changed in 100 years. Probable cause in a legal sense is those facts and circumstances that would lead a reasonable and prudent person to believe that a crime has been committed. Let me give you an example. Let's say that you have a police officer who's following an individual who happens to be weaving across the line back and forth, and it's 3 o'clock in the morning, or the person doesn't have their headlights on at the same time. Then that is probable cause that the police could believe, who would be a reasonable and prudent person, that the person might be under the influence of alcohol, so they can pull that person over. That is called probable cause.
Well, they could have been perhaps a little sleepy.
That's correct.
Might have worked a long night job.
That is correct.
Might have been driving a long way.
That is absolutely correct, but it's still probable cause
Yes,
that a
to stop
crime
him.
may be committed.
Yeah.
Once he pulls them over, a crime may not be committed, and then you let that person move on about his business.
I know we're discussing the arrest process and how it begins. Nowadays, with all the technology that we have, and everybody walking, including the baby, the mama, and the grandmama, has a cell phone
That's true.
automatically. And nowadays, with the technology, it shows a lot of times how the arrest begins.
Yes, absolutely. With video these days, with cell phones, it is not uncommon for someone to record a police officer arresting somebody on the scene, or police brutality for that matter, or an individual actually attacking a police officer. The good thing about technology, it has its pros and cons. It protects the police, first of all, but it also protects the citizen.
Right.
It goes both ways. It also shows times where police officers violate the law, and that police officer is arrested, like the Charleston, South Carolina incident.
Yes.
So video and technology these days, it is so advantageous to our society.
And I think, you tell what you think, I think it has been very instrumental in showing who's at wrong and who's at fault.
That is absolutely correct, because many times you'll see that the police has overreacted, simply committed brutality on an innocent person, and then you have times that people commit crimes on police officers, and when that shows up, that person is generally convicted in court. So it does go both ways.
So it protects both sides.
Absolutely, no question.
And then too, now the police are having more cameras on them.
Yes, body cameras.
Body cams.
Absolutely.
Talk about that.
There was a lot of controversy going into body cameras. Let me tell you about that. Generally, a body camera was made for a police officer in his patrol car. When he gets out of his car, he's approaching the vehicle, and everything that's said and done is on that camera. But the other issue is a First Amendment privacy issue. That camera was not meant to go in someone's private home. And what if they're naked in their pajamas or sleeping? That, to me, is a violation of someone's First Amendment rights. So yes, we do have a place for body cameras, but sometimes it crosses the line when it goes into someone's private residences.
I can understand that. So it can go too far.
Too far, absolutely.
And it does have its limits.
That is
and
correct.
It has advantages and disadvantages when it comes to situations like that.
That is correct. Now, when they're going into someone's residence, it also has advantages and disadvantages. The advantage is that if they go in someone's house and all of a sudden the suspect pulls a gun on a police officer and he has to shoot that person, that body camera is going to capture and show that that officer was justified. But then there's other incidents where that is totally unnecessary to have a body camera in someone's residence.
I can understand that, because that's an invasion of privacy.
Absolutely,
too.
no question.
Okay, we've gone through the process of how the arrest began. What I need to know now, can anyone get a bond?
Let me explain that. When a person is arrested, it depends on what they're charged with will determine if they get a bond. It just depends. For an example, in Georgia, if a person is arrested for a misdemeanor, such as DUI, simple battery, speeding, then the judge must automatically give them a bond. You cannot be denied a bond on a misdemeanor. That is no question. But if you're charged with a felony, such as aggravated assault, the judge has discretion to grant or deny a bond in a felony case. For an example, if it's a murder, then a magistrate court judge cannot give you a bond in a murder case. That must be done solely by a superior court judge. We have what's called 7 deadly sins, such as murder, false imprisonment, kidnapping, aggravated child molestation. There are certain crimes that only a superior court judge can grant you a bond.
And I know you've been practicing for 20 plus years.
23.
I know it's right up there. How likely is it that someone perhaps will get a bond for murder?
Let me tell you, I've represented quite a few people charged with murder, and not a single one has ever got a bond. Not a single one. It's rare. And it doesn't mean that it doesn't happen, but it is rare that someone's charged with murder gets a bond, unless at his bond hearing it shows that it might have been self-defense or some other extenuating circumstances.
As you know, I've been sitting as a judge for over a period of approximately 20 years, and there's only one case that I can recall that I gave a bond to.
Absolutely.
Only one case. And I thought it was appropriate. It turned out very well because it was a child, a teenager, who had been bullied. And no one would listen to this child. And he had begged the principals, the teachers, and everyone. No one would listen.
Absolutely.
And that child, stressed out, got a gun. So when the bully approached him again, he shot the bully and unfortunately killed another child.
Very tragic.
And so he came to court with all his family, his mother, his daddy, and uncles and aunts and everybody. And it was a very established family. I never will forget the case. Mother worked at Grady, and the daddy was a modern bus driver. I did let him go home into a trial with great restriction.
Absolutely.
That he must always be in the company of his parent or some other authorized adult.
Which means you used your judicial discretion
That's
when you
only
granted
one
him a bond.
time out of all the times that since I've been practicing law that I have done that. Only
Absolutely.
one time in a murder case.
Fantastic.
So, like you said, you would know better, more that you normally don't get a bond.
No, not at all. But
In a murder
it
case.
is those rare exceptions that a defendant will get a bond.
And I don't know whether you're familiar with the case up in Gwinnett. Well, unfortunately, this young adult drove into somebody else's yard, and the youth was killed, young adult. I'm not sure what they did with that when this senior citizen, afraid perhaps for their life.
I remember that, yeah, and that senior citizen did get a bond because it was shown that that senior citizen thought that that person was coming to break in their house, and that was just the opposite. But sometimes tragic accidents do
But
happen.
that's 1 in a million, though,
That's
right?
correct, absolutely.
So it is possible to get a bond, but serious misdemeanor, the deadly sins that you discussed, those are the ones you may not get one.
That is absolutely
And that's
correct.
why they allow the higher judge in Superior Court to make that major decision.
That's correct, because they have a task to make those discretion in terms of whether an individual will get a bond or not.
Then too, isn't also whether there may be a threat to the community. What are some of the requirements to get someone to bond?
Absolutely.
What are some of the points,
Absolutely.
Attorney Patterson?
When someone goes for a bond hearing, they have a threshold to meet, and the burden is on the defendant. It is not on the prosecution. The burden is on the defendant to show a number of things. Number one, that he's not a risk to flee the jurisdiction. Number two is that he won't commit any crimes while he's out on bond. Number three is that he won't obstruct justice while he's out on bond. And number four, what is that fourth? And I'm having a mental block here. I'm having a mental block, but it's actually four of them. And if the defendant can actually show those four, then the judge generally will give them a bond, but it's not absolutely required. The judge can still deny it. But the only way the judge can deny it is that the judge has to show at least one of those
Contacts
four.
with the community.
That's correct. Contacts with the community. That is correct.
So if the person, for example, if they are, well established, let's say they had a good record in the community and they bought a home, they got children in local school, they've been on their job 15, 20,
Absolutely.
30 years, you look at the risk of likelihood of that person leaving the community.
That is correct.
Because he has so many attachments to the community, it's not likely there's going to be a flight.
That is absolutely correct. And in those situations, a defendant would generally get a bond.
But if someone who's coming through the town, no contacts with the community, and no long-established career or anything, the likelihood for that person is very slim to none.
Absolutely. I've had clients who were charged with drug trafficking coming through, say, Troup County, Georgia, and they live in California, passing through, got caught with drugs, and they just don't get a bond because they have no contacts to Georgia, and they will be a likely
Flight
candidate to flee. That's correct.
to flee. So those are some of the areas that must be touched on when you're talking about getting a bond.
Absolutely.
It's all left up to the discretion of the judge, is that right?
That is absolutely correct. And even if the judge denies you a bond, you have the right to appeal it, but 99.9% of the time, the Court of Appeals will affirm that denial.
Because there's a lot of concern and risk, because if the suspect gets loose and commit further crimes.
Absolutely.
Are you familiar with the case about the gentleman in, I think it was in Texas? They kept letting him out. I think he was from Mexico or somewhere. They kept letting him out, and eventually he commenced to do more and more murders and more crime. And they said the judge should not have perhaps let him out.
Yeah, it happens all the time. But then again, there are sometimes in those countries like Mexico, there are other influences, a lot of corruption going on. So that's why that happened in that country as well. But it is no question that the judge makes the final decision on whether you get a bond or not.
Because there's a lot of risk he takes.
Absolutely.
To let that person loose.
Absolutely.
And then sometimes, how about these domestic violence cases? Let's say a man brutally beat his wife or girlfriend, and you let him out.
Right, and then 2 days later, that woman is dead. Then the media is going to jump all over that judge, no question.
So those are risks and concerns.
Absolutely, and every judge thinks about that depending on the nature of the case.
So there's a lot at stake.
Absolutely.
When you're considering to let someone have a bond.
No question.
All right. Okay, we're going down to the steps of arrest and the possibility of a bond. And so now the suspect is charged with a crime. So what is an indictment? Does that mean a person is guilty if they are indicted?
You know, well, you see on TV or you hear on television all the time that John Doe was indicted for murder. John Doe was indicted for vehicular homicide. Most people think when you hear the word indictment that the person is guilty. That is not what indictment means. An indictment is simply a piece of paper that is your formal charges of what you're charged with. An indictment is where you get to go, where the DA takes your case before the grand jury and present it to anywhere from 17 to 24 people and tell those people what actually occurred. It's a one-sided situation. So 99% of people that cases are taken before the grand jury is indicted, but it is only the formal process to get you to trial. It has nothing to do with innocent or guilt. That comes later when you have a trial.
And perhaps in an extreme case where you are suspected of something, but for some reason, let's say you was out of the country, in the hospital in a coma. Under those circumstances, those extreme cases, what's the likelihood of being indicted then?
Well, let me tell you, in Georgia, you can indict a ham sandwich. Let me tell you.
It doesn't take much.
It doesn't take much because it's a one-sided situation. I mean, there's an old theme in Georgia that the district attorney can indict a ham sandwich. Absolutely.
So, but do you find that, let's say you're indicted of a crime, an individual indicted of a crime, does he have to fight as hard as someone who truly did it? Let's say someone who didn't do a crime, but they're accused of the crime.
You know, the standard is supposed to be innocent until proven guilty.
But in practicality,
you're guilty until you prove you're innocent.
In reality, that's how it works.
And that's why defense attorneys are so important, because it takes a lot when you get accused of a crime. If that jury believes that you're guilty, it's a done deal. So that's why it's so important that the lawyer that you pick to defend you is very, very critical.
Let's regress and go back a minute, Attorney Patterson. We talked about the arrest process. When should you call a lawyer?
The moment that you find out that you're a suspect, or the moment that you get arrested, it is important that you don't make any statements to the police. You need to call a lawyer right away. Now, if you happen to be in custody, you do not want to make any statements to the police because they're going to Mirandize you, which means anything that you say to the police can and will be used against you in a court of law. So if you're smart, you want to keep your mouth shut and hire an attorney and let your attorney do the talking.
How about some of these people, I'm sure you ran across them, they think they got a lot of mouth, they can talk themselves out of anything.
Absolutely.
But you and I know as a lawyer what key words can really trap you, because the judges and the lawyers and the police and everyone listening to you, the terms that you made.
Absolutely.
Is that possible you dig a bigger hole for
Oh,
yourself?
absolutely.
A bigger hole for yourself?
There are clients that will say, well, I didn't commit a crime, but I was definitely there. I mean, just saying you were there is enough to get you involved. So clearly it is important that when a person is arrested, when they read you your rights, the Miranda rights, and they tell you point blank, anything you say can and will be used against you, and you have the right to remain silent.
Some smart people who got a lot of mouth, they think they can talk themselves out of anything.
Absolutely.
And so what they started doing, rambling off to the police.
And
does that make your job harder as an attorney?
It does. It digs the defendant or the client a much bigger hole, and it makes my job even more difficult, because if you don't make any statements, you're not boxed in court as to what you've already said. By keeping quiet, then we get to formulate our own defense.
So it can seriously damage and jeopardize a good defense.
In every case.
And make the work harder for the lawyer.
Absolutely, no question about it.
All right. What's the difference between an indictment and a formal accusation?
As I previously explained, an indictment is solely the formal way where your case is taken before a grand jury and you get formal charges. And formal accusation, there's no grand jury involved in that process. That is simply where the prosecutor simply types up a piece of paper and signs it, and then you're formally charged. There is no grand jury involved in a formal accusation. For an example, a traffic ticket, if you look at any traffic ticket, it says uniform, citation, and accusation. That is also an accusation, as well as a formal accusation. That's an 8.5 by 11 sheet of paper that the prosecutor drafts him or herself. So yes, the difference is there's no grand jury involved, but the process is the same once you get to court, because that formal accusation takes you to court just like the indictment does.
And when you think it's necessary, they make their own decision as to which one they're going to use?
It's pretty simple. If it's a misdemeanor, then generally there is no indictment, because you don't have to have an indictment to charge someone with a misdemeanor.
Right.
Now, there are exceptions to that. For an example, let's say, Sheriff Victor Hill. Remember, he was accused of being in this house with this real estate agent, and
Right.
she apparently got shot.
Yeah.
They charged him with reckless conduct, which is a misdemeanor.
Right.
But if you notice, Danny Porter, the DA, took his case before the grand jury. They
Right.
didn't just do a formal accusation, although it was a misdemeanor.
Right.
That's because police officers who are public officials have the right to have their case taken before a grand jury. That is a law in Georgia that cannot be gotten around. So yes, there are times that misdemeanors must be taken before a grand jury, such as in the form of a police officer or a public official.
That was an unfortunate event for Sheriff Victor Hill.
Absolutely.
So I hope things work out for him.
Absolutely.
Okay. Could you tell us how is a jury selected?
Oh, that is a real involved process. It depends on whether it's a misdemeanor or a felony. Let's start with the misdemeanor. Let's say that a person is charged with DUI. Then the law allows him or her to have 6 persons on a jury. Now, when you're picking a jury, the judge is going to bring in 12 jurors, and you get to question those jurors. I get to question them as a defense attorney. The prosecutor gets to question the jurors as well. You get to ask questions about bias on different aspects, whether they drink and drive, whether they opposed to alcohol, whatever the nature of the case is, you ask those type of questions. After both sides get through asking questions, then the prosecutor get to strike 3 of those individuals. You're really not striking a jury, you're deselecting a jury. You're getting rid of those individuals that you do not think will make a good juror for your case. So the prosecutor will then strike 3 of those individuals, the defense attorney strikes 3, and out of those 12, then you have 6 left. That is how you get a 6-person misdemeanor jury. As it relates to a felony trial, then you have anywhere, the way it works, that a superior court judge may bring in anywhere from 38 to about 45 jurors. In the same process, the prosecutor gets to question and the defense attorney gets to question them. At the end of all that, the prosecutor gets 9 strikes and the defense get 9 strikes. And at that point, you have 12 people left on a jury. That is how you pick a jury in a misdemeanor and a felony case.
I understand, being a juror is a civic duty.
Absolutely.
How important is that to winning or losing the case?
Oh, let me tell you, it's twofold. First of all, picking what you call the right juror is so important. Although they don't know you and you don't know them, you have to be able to gauge the vibes to determine whether you think they'll make a good juror or not. But the biggest problem that I find in jury selection is that, and I hate to say it, is most African Americans don't want to serve on the jury. They will come to court and the judge will say, is there anybody here have any reason why you can't serve? They will come up with a million reasons why they don't want to serve. For an example, they'll say things like, well, I got to work today. But remember, jury duty is a civic duty.
Right.
And when you can't be terminated from your job because it is a duty. And so, but they come up with reasons, and what they fail to understand is that if you have an African American defendant,
Right.
you want African American jurors. So
To understand
the lifestyle. And
Right.
so when they decide to find ways to get off this jury, then it hurts the defendant, because then you're going to have a jury that's composed of predominantly whites. And not that whites can't be fair jurors,
Right.
because I've had all white jurors and they found my client not guilty.
Right.
But still, you want it to be a cross-section of the community. Black, white, Asian, the whole cross-section.
Because it says you be judged by your peers.
That is correct.
Right?
That is correct.
And that got great meaning, does it
It
not?
does, because when you don't have African Americans on a jury and the defendant is African American, then you don't have jurors of
Who
your
can
peers.
understand
That is correct.
what you're doing.
That is absolutely correct.
I'm sure that can also have some play into different cultures as well.
Yes, it does. And that's why it's so important that as African Americans, we must want to serve on juries so that we can do our civic duty and make sure a defendant truly gets a fair trial.
A lot of people don't think ahead because that maybe someday when that same person, family, a loved one is in trouble, or they have lost a family member through death or whatever, there's going to have to be a jury to listen to that felony case.
That's correct. And then when there are no blacks on that jury, that same family member will come back and say, well, he was convicted because there was no blacks on the jury, when they themselves refuse to sit on the jury. Absolutely.
And people look at it, well, it's not concerning me. Yes, it does.
It does. The whole criminal justice system involves everyone.
That's why everyone should go head on and provide this civic duty,
Absolutely.
because it would help not only their community, maybe sometime down the line that it may help their family or their friends when they have loved ones in trouble or they have lost family members due to some unfortunate tragedy.
Absolutely. No question about that.
Okay, I think you all explained some to us about probable cause in police. I tell you what, for right now, I think it's a great time for a break.
Okay.
Okay, and we'll be right back with you in a moment. Thank you for listening. Stay tuned. Picking back up where we left off, let's talk a little bit more about probable cause. And for example, if you are walking, and tell us if there's any probable cause someone pull you over, or they didn't have probable cause to stop you while you was walking. Tell us more about that.
Sure. A police officer cannot at any particular time make an arrest without probable cause. In other words, as I described earlier, if a person is driving and it happened to be weaving, then as long as that police officer can reasonably believe that that person is committing a crime, such as going over the yellow line, improper lane change, then he can pull that person over. If an individual is walking down the street, minding their own business, now remember, it is not illegal for a police officer to just approach you even when you have not committed a crime.
Okay.
They can approach you, have conversation, ask you your name, all of that. There's nothing illegal about that. They just can't detain you unless they have probable cause to believe that a crime has been committed.
All right, let's say you're walking down the street. You might be going to the store to get a Coke or what have you, and they said, may I see your ID? And you don't have an ID on you, then what?
Well, there's nothing illegal about not having ID on you, but they do have a right to ask. But it is not a crime not to have identification, but you also have a right to say, officer, am I being detained or am I free to leave? You need to ask that question, because if he says you're being detained, then he has to have probable cause at that point to detain you. And just not having identification on you is not probable cause.
All right, I don't know whether the persons told me all the facts. They said, well, I didn't have an ID, so the police arrested me. Have you heard of a situation like that?
All the time, absolutely, but generally they have more reasons to ask for ID. For an example, you're walking around a store that's closed at 3 in the morning and you look like you're casing the store to break in it, then that's probable cause for them to approach you and detain you. Then if you don't have ID, they still have probable cause to call your name in and find some way, and sometimes they arrest a person for prowling just so they can make sure.
Look highly suspect.
That's correct.
Look highly suspect. Okay. When a person goes to trial, what are the options that a jury has in terms of verdicts?
Oh, most times the judge only tells a juror that they only have two options. That's guilty or not guilty. Let me explain. In order for anyone to be convicted in Georgia or anywhere in this country, the jury has to find that the state has proven its case beyond a reasonable doubt. Now that's a very high standard.
Tell me more about reasonable doubt.
Yes, let me explain that. For an example, in civil cases, it's by the preponderance of evidence, which is just like tilting the scale. So in a car accident case, whichever one tilts the scale the most, then that's preponderance of the evidence and that party wins. But in a criminal case, it is beyond a reasonable doubt. In Georgia, this is the definition. It says no person accused of a crime shall be convicted of a crime until such time that the states prove its case beyond a reasonable doubt.
Now, whose burden is that?
That is the state's burden. The burden beyond a reasonable doubt never shifts to the defendant to prove his innocent. A defendant does not have to do anything to prove his innocent. Technically now, even though we know the difference, but the state has to prove it beyond a reasonable doubt. And then
when the state or the prosecution closes his or her case, and you as defense attorney, the great defense attorney that you are, if they have not, you feel with the evidence that was brought, have not made out their case, what move would you make at that time?
Then you would ask the judge to do what's called grant a directed verdict of acquittal. That means if you're saying, Judge, the state has not proven this case beyond a reasonable doubt, so don't let this case go to a jury. You just need to remove it from the jury and find my client not guilty. Most of the times, about 95% of the time, the judge will say, well, I'm going to let the jury make the decision and deny that motion. But then there's about 5% of the time the judge will say, Mr. Patterson, you're absolutely right. The state has not proven this case, and take it away from the jury and find that person not guilty.
Because as you know, every crime has certain elements that must be met.
That's correct.
And if one of those elements is satisfied to be met, if there's one that has not been met by the state.
That's correct. And let me give you an example.
All right.
Driving on a suspended license. In order to be guilty of driving on a suspended license, there are certain elements that must be met, and the state has to prove each and every one of those elements. For an example, this is the definition of driving on a suspended license, and this is what the state must prove. It is unlawful to drive a vehicle in Georgia on any public highway while that person's license is suspended, revoked, or terminated, then the state has to prove, one, that the person was driving. That's the first element. On a public street is another element, and that the person knew that their license was either suspended, revoked, or canceled at the time they were driving. Now, there's an exception to that most people don't realize. It is not illegal to drive with a suspended, revoked, or canceled license on private property. It must be on a public highway.
So private property, would that be a shopping center?
That is correct. Now, there's an exception to the shopping center as well. If that shopping center has a thoroughfare that takes you to a main street, then that's an exception. But if it's a shopping center where you just have one way in and one way out, and it doesn't connect to a major thoroughfare, then you cannot be found guilty. But there is a slight exception.
So, for example, I'm at the shopping center and my mother don't want to walk. Let's say if I had a mother or auntie, and I'm on the lot of the shopping center, so I can circle from one store all the way to the back of the shopping center, even though I don't have license.
That's correct. Or your license is suspended.
My license suspended.
As long as you don't drive on a public street, that is absolutely correct.
So, and I'm gonna ask you this because years ago there was tough things in the news. Suppose someone is caught on the side of the highway not driving. They could be incapacitated, ill, or whatever reason. And would that be considered driving?
Great question. Yes, it depends on the charge that they're charging you with.
Okay.
For an example, if you're charged with driving on a suspended license and you're on the shoulder of a highway, then the law infers that you were the driver if there's no one else in that vehicle with you, or if you happen to be sitting under the steering wheel. So yes, there's an inference. So you can still be convicted, because if a jury believes that there's an inference that you drove that vehicle, you can be still convicted, although a police officer or no one saw you driving. That is
let's
correct.
say I'm sitting in the back seat. Maybe I'm knocked out asleep. I'm tired driving work or whatever. I'm on the back seat. That inference will be harder to meet in circumstances like that.
That is correct. You hit it dead on the nose, because anyone could have walked away from the driver's seat and left you in the back seat.
Right.
Now, it also goes back to whether that person in the back seat is making any statements. As I said, when people make statements to the police, for an example, that individual in the back seat may say, well, I drove here, but I got sleepy, so I got in the back seat to lay down. Then clearly that person, it can be inferred that that person was driving. That's correct.
But he said, my driver, I don't know, maybe he left me.
That's correct. So it depends on what you say to the police and how
So
you
that's
say it.
another reason why you should zip it
That is absolutely correct.
when you are arrested.
That's correct.
It's not good to talk yourself so-called out of a crime, because what you're really doing is talking yourself more into the crime.
And to a conviction.
That
is correct.
And I'm sure Attorney Patterson, when you get these cases, it requires a little more work. You have to charge a little more.
Absolutely.
Is that right?
Absolutely.
Like in a job, the
Yes.
more hours you put in, the more you're going to be paid.
Absolutely. But I try to be reasonable in my fees.
Yeah, but you're a hard-working attorney. I know you're
Thank you.
excellent on appeal.
Thank you.
That brings me to another question that pertains to appeal. If a person is found guilty in a case, and what can he or she do if they don't like the outcome of the trial?
Sure, they can do what's called a criminal appeal. Let me explain that process. Let's assume a person is convicted of DUI. Then they can do a certain type of appeal. They can do what's called a direct appeal to the Court of Appeals, meaning that you have 30 days from the day of your conviction to file what's called a notice of appeal. Once that notice of appeal is filed, then the conviction still stands. Then it goes to the Court of Appeals, and it takes about 9 to 12 months before that court determines whether your conviction is wiped out or not. They can also do, within 30 days of their conviction, they can do what's called a motion for a new trial.
Right.
Then you'll go right back before the same judge that you were convicted in front of and argue to that judge why your conviction should be reversed. If that judge agrees with you, then your conviction is wiped out. But if you take the direct route, then you've got to wait all the way to the Court of Appeals to make their decision.
But another point, I want to ask you this. If you file a motion for a new trial, will that halt the time limit, 30 days of filing a direct appeal?
Great question. Yes, it does. If you file a motion for a new trial, you never have to file a direct appeal until your motion or your hearing is heard in front of the same judge that you were convicted in front of. Once that judge makes a ruling, let's say the judge says, I'm denying your new trial, then your second 30 days start
The clock starts ticking at the time of that order denying you.
That is correct. And it starts ticking from the time that it's filed in the clerk's office. Then you have 30 days from there to file your notice of appeal to the Court of Appeals.
So that gives you time.
That is correct.
As you know, I'm pretty sure you do, are appeals expensive or inexpensive?
Oh, very, very, very expensive. It depends. For an example, if a person is convicted of murder, then you're looking at a transcript that may be, 1,300 pages. So lawyers charge for having to read all of that.
Because what are we selling? Time.
That's correct. That is
after
correct.
you read all that 1,300 pages, you have to analyze.
That's right.
Digest.
Yeah. And you have to look for the errors.
And then find case law to support your points.
And then do your brief. That is absolutely correct.
And that is time consuming.
That is correct. And in a misdemeanor case, it's the same process, but it's a lot less work because obviously a DUI trial will be shorter than a murder trial.
Right.
But the process is the same.
So it depends on how serious the charges are, whether people want to invest the money into having an
That's
appeal.
correct. And sometimes people cannot afford an attorney to do an appeal, so they have to get a public defender.
Right. And all of us know the public defenders are pretty much overloaded with a lot of cases.
Oh, overworked and underpaid, no question.
That's a big job.
Yes.
And people don't understand perhaps until they have to be in a public defender's shoes themselves. You got
correct.
many cases. Every case, it has so many elements in it.
Yes, public defenders have to do a whole lot of work because they get one paycheck every 2 weeks, but the workload increases.
Insurmountable. Okay. And some people, as we know, and you've been in practice a while, they may say they don't want a public defender. They want a so-called a real lawyer.
That's right.
What is a public defender versus a so-called, quote, real lawyer?
The public has a perception of basically it's a bad perception, because when people say that I don't want a public defender, I want a real lawyer, they fail to realize that a public defender is a real lawyer. A public defender and a lawyer such as myself, we all have to go to law school. We all take the same courses.
Right.
We all have to pass the bar exam.
And they are as real as we are, right?
As real as we are. But the public perception is that since they work for the county, that they would do a less sufficient or adequate job for the client. And that's just not true, but they get a bad rap. I know some public defenders that are so good to where they should be hired or get called upon on a daily basis. But unfortunately, there are also public defenders who just go through the motion and don't do anything. And that's why the bad
But those
rap
are the ones who are diligent. Be real now, the so-called some real lawyers may have that same attitude as well.
Oh, yes, absolutely. It doesn't matter if you're a public defender or a private lawyer.
So it goes for the so-called real lawyers and the public defenders.
That's correct, because there are private lawyers who do equally as bad a job as some public defenders who do bad jobs. So no matter which you have, there are good ones and bad ones on both sides.
On both sides.
That is correct.
Depending on how diligent they are.
That's correct.
Such as yourself.
Thank you. Thank you.
You've always been so diligent,
Thank
Jackie.
you.
Attorney Patterson. Okay, if a person is convicted at trial, what other options? I think we discussed that already.
Yes, we have.
If they're convicted, then they can appeal, either have a motion for new trial,
Absolutely.
and that's left to the judge on a new trial where they're going to give them one if you point out some error that was made during
That
the
is
trial
correct.
of the case.
Absolutely.
Okay?
And by the way, when you do an appeal, only about 75%, well, let me rephrase it, 75% of appeals are affirmed. In other words, if you're convicted, you have a 75% chance that that conviction will stand. There's about a 25% chance, based upon your case, that your conviction will be thrown out.
And of course, when you discuss with your clients, the time and the cost of appeal and the strength of the evidence that you have or don't have, you do this for your clients so they can make an informed decision.
Absolutely, because under the Georgia rules of professional conduct, you can never promise a client the outcome of a case. In other words, you can only say that I'm going to do my very best based upon the law and my legal experience. But at no time can you say, if you hire me, I promise you I'm going to get your conviction wiped out.
That's an unethical act. Is that not?
That is totally unethical.
You can tell the client, you can prompt them, you're going to give them your very best
That's
and
correct.
diligently work for them. But I don't know about you
But you
and
can't.
other lawyers, we don't have a crystal ball.
That's correct, and you cannot make
And you
promises.
cannot guarantee promises. And I'm sure there are comrades out here who will do this to get people's money.
It happens all
And
the time.
those are the ones really who don't work diligently for justice for their client.
Absolutely. I've had cases where people come in and I review their file and I'll say, sir, let me just be honest with you. I would love to be your lawyer, but if you hire me, you're wasting your money because I do not think we'll be able to win this. And then they'll thank me for being honest about it. But I just cannot take a case knowing up front that I cannot help them. If there's a small chance that I can help them, then I will certainly.
And you let them assume that risk.
That's
and
correct.
tell you whether they can want to invest their money in attorney's fees, take the losses of what happens.
That's correct. You hit it dead on the nose.
And then sometime we then discuss it, to give them the facts in the case, whether there will be a plea. Suppose you got a video of something, and the client you represent, they got them on video.
Yes.
How you gonna overcome some of this video?
Yeah, it's amazing. Sometimes videos can help a case, and videos can also hurt
a case.
For an example, in a DUI, you have people that sometimes that are so intoxicated to where they can't even stand up. They don't know where they are. They don't know what time it is. Those videos are devastating at trial, and in most cases of that nature, your client generally enters a guilty plea.
All right. Let's move on a little bit. This is the holiday, and as you know, a lot of people in the community around the country celebrate, and they're gonna want to have a little spirits,
Absolutely.
drinking and driving.
Libations.
Libations. What's the definition of a DUI?
Well, in Georgia, the definition of a DUI, it is illegal to be in physical control of a moving vehicle while under the influence of alcohol or drugs. Now, there are several different types of DUIs in Georgia. You have DUI alcohol, you have DUI drugs, DUI vapor, you have several DUI marijuana, you have DUI cocaine. It can be a number of different types. But now the police can charge you, for an example, if they think that you're under the influence of alcohol and cocaine, they can charge you with DUI alcohol, they can charge you with DUI drugs, they can charge you with DUI marijuana, vapor, whatever they think they can prove. But if you go to trial, say, on 5 different types of DUIs, even though it's only one DUI, but they can charge you in 4 or 5 different methods, you can be convicted of all 4 or 5, but the judge can only sentence you to one of those.
One of them.
That's correct. And the rest of them merge.
I'll say a person is doing this holiday, we're in the holiday season, driving about, and the police say, sir, I believe you're intoxicated. Will you take this breathalyzer test or blood test? Can that person refuse to take it?
Oh, absolutely. It is no question. The public must understand that if you get pulled over for suspicion of driving under the influence, that first of all, if you get arrested, then the police has to read you what's called implied consent. It's a little card that they pull out that says Georgia law requires you to submit to a state-administered chemical test to determine if you're under the influence of alcohol or drugs. Mm-hmm. Once they read you all of that, they'll ask you, will you take the breath, blood, or urine test?
Right.
You have an absolute right to say, officer, I'm not taking any test. Now, there's an exception to that. Generally, that ends it. The officer will then take you to jail, but without a blood, breath, or urine test, and when you make bond, you go to trial and try to prove your innocence. But a few years ago, the legislatures decided, well, we're going to create an exception to your refusal.
Okay.
If a police officer, if you refuse to give them blood, urine, or breath, then they can go to a magistrate court judge and get a search warrant for your blood. The judge will then sign a warrant. They can take you to jail, strap you down, get a nurse or to a hospital, and force blood out of you. I find that law to be totally unconstitutional. And in fact, the Georgia Supreme Court has never ruled on that. I'm waiting on the right case to take that to the Georgia Supreme Court, because think about it. If Georgia law gives you on one hand the right to refuse, how can they then turn around and say, we're not going to let you refuse and we're going to draw your blood?
But how long would it take for a magistrate, though? I mean, we know magistrate work late hours, beyond 5 o'clock.
Absolutely.
We know that. Well, what's the general process? How long would it take for them to get that warrant to take your blood?
Well, it's done electronically now, so they don't even have to be in front of the magistrate court judge. The magistrate court judge can be at home, and the officer can be at the precinct or at the jail, and they'll do video conferences. and the judge will then sign a warrant at home, and that is electronically sent to the officer, and the person is
It'll
arrested.
be instantly.
Instant,
With
absolutely.
the new, all this technology we have.
Absolutely. But I strongly believe that the fact that a person has a right to refuse, and then an officer can go to a magistrate court judge and get a warrant for his blood, that is clearly.
Sounds like conflicting laws.
Absolutely, clearly unconstitutional, because the state can't give you one right and take away the same right.
Let's say the person refused to take a DUI test of any sorts. Can the prosecution, let's say they don't get a warrant from the magistrate judge to get a warrant to receive your blood or breath or whatever they try to take, will that be held against that person?
Oh, absolutely. Georgia law says that if you refuse to take a blood, breath, or urine test, once you get to trial, that refusal is admissible in court against you. I don't have a problem with that. I would rather have a client who has refused everything, because you can explain your refusal in court. The person may be afraid of needles. The person may not want to put, may feel that the breath test machine is not clean. There's a number of reasons why you can explain that. But I would rather have a client any day who refused to take all tests versus blowing into that machine or giving blood, because once you have a 0.8 or more in your system, under Georgia law, you're technically DUI.
Then too, I'm sure you've been a great defense lawyer as you are. How about machines they are using? Are they accurate? When the last time they've been calibrated? Do they have a log?
And I attack those. If a person happens to have a 0.8 or 0.10 or 0.13, then I immediately subpoena those logs to see when the last time that machine malfunctioned. Because if you can show that it has a history of malfunctioning and you present that to a jury, then a jury could maybe say this test result can't be correct and find the person not guilty.
Because the machine is defective.
That's correct.
Okay, so you got to be thorough in your investigation. Do your homework.
That's correct.
Do your homework.
Absolutely.
How about a field sobriety test? It's the same thing if he fails to take it?
Now that's different. Certainly, a field sobriety test, such as walk the line, stand on one leg, and doing the eye test, those are voluntary. You have a right to refuse those. Now, the law doesn't say that those can be used into evidence against you, but they are used in evidence against you on every occasion.
Every time.
Because the officer has a right to testify to his investigation. But the only one that's an inference that can be used against you is when you refuse the blood, breath, and urine test.
Okay. So the sobriety test is a little different.
That's correct.
So will the police take you to jail if you refuse to take these tests we just discussed?
Oh, great question. Let me tell you, if a police officer smells alcohol on you, whether you take any test or whether you voluntarily take tests, there's about a 99% chance you're going to jail. Because I tell my clients all the time, if you've been drinking, you want to refuse everything, because most times you're going to get arrested anyway. Whether you take any test or not, that officer is still going to take you to jail for DUI. But your chances of being found not guilty is greater at trial when you refuse to take tests versus giving a blood, breath, or urine test. Absolutely.
So it can work against you.
Oh, absolutely. But no matter what, if an officer smells enough alcohol and think that you're impaired, then you're going to jail whether you give up your blood, breath, or urine, or whether you refuse all
You
tests.
still can go down.
That's correct.
Okay. What is the punishment for a first-time DUI conviction?
Yes, a first-time DUI conviction, the maximum punishment is 12 months in jail, $1,000 fine, 40 hours of community service. You have to take a drug and alcohol evaluation, and you have to go to DUI school. That's the maximum punishment. Now, then you lose your license as well.
I'm going to ask you,
Yes.
will they be able to drive?
Yes, you do lose your license, but if it's a first-time offense, the judge can give you what's called an affidavit of first conviction, to where you would take that piece of paper to the DDS and get a permit to drive on for 120 days. Now, that permit is only good for the state of Georgia. You cannot drive outside of Georgia with that permit, otherwise you'll be charged with driving on a suspended license. After that 120 days are up, then you can apply to get your full license reinstated, but you'll still have a DUI on your record.
But those requirements you're given to fulfill, you must fulfill those, right?
Oh, yes, you have to do those in order to get a driver's license.
And so
back.
once they have their license taken because of a DUI, will they be charged a reinstatement fee to get your license?
Yes, it's a $210 reinstatement fee. That is absolutely correct, $210.
Great. Mr. Patterson, it certainly has been great having you on the show today.
Thank you. Thank
and
you.
I'm sure you have given our audience a wealth of information that'll be useful in their lives. And I thank for having you here. I respect you as an outstanding defense attorney here in the Metro Atlanta area.
Jackie, it's my pleasure.
And I know your clients appreciate you and this community for having you here. And you just got to have so many talents.
Thank you.
It's been a pleasure having you here today, and I hope to have you back again soon.
Thank you so much. I enjoyed it, Jackie, and I look forward to seeing you soon.
You will.
Thank you.
Thank you.